Imagine this. A brand approaches you with a dream collaboration worth 5 lakhs. Now you're excited, your follower count is growing, brands are noticing you, and this deal feels like a major breakthrough. You quickly sign the contract without reading all the clauses because let's be honest, who reads every page of a legal agreement? A few months later, you discover the brand owns your content forever. You cannot work with competing brands for the next 2 years, and they have the right to terminate the agreement without paying you. And if your social media post creates any legal issue, you will be bearing the liability all alone. Sounds unbelievable. Unfortunately, this is not a fiction. This is the reality faced by many influencers and content creators around the world. Today, we are exposing the dark side of influencer contract and the legal traps that every creator must know before signing their next brand deal. Now, the influencer economy is worth billions of dollars globally. Brands are spending enormous amount on influencers because consumers trust creators more than any traditional advertisements. But while creators spend years building audience, many unknowingly sign contracts that heavily favor brands. Behind the attractive payment figures and glamorous campaigns often lie clauses that can damage careers, reduce earning potential, and create significant legal risk. So today we'll break down the most dangerous clauses found in influencer contract, discuss real world examples, and explain how creators can protect themselves. Let's begin with one of the biggest mistakes a lot of influencers make. You create a reel, you write the script, you shoot the video, you edit the content, you post it on your account. Naturally, you assume that you own the same. Not necessary. Now, many influencer agreements contain, intellectual property clauses transferring the ownership to rights to the brand. Sometimes the transfer is also permanent. Now imagine creating a viral video for a skincare company. The campaign ends after a month, but years later, the brand continues using your face, your voice, and your content in advertisements without paying you an additional rupee. Why? Because a contract gave them perpetual usage rights. Now, as an IP lawyer, I often advise creators to carefully distinguish between a content license and a content ownership. A brand may need permission to use content for a specific campaign. That's very different from giving them ownership forever. Before signing, always ask these few questions. How long can the brand use my content? Where will they use it? Whether it's only on Instagram, uh, only on YouTube, only on TikTok, etc. Can they modify it? Now, a lot of times brands ask for the raw footage also and then they edit and modify the same. Will I receive any additional compensation? Now, these questions can save you from significant loss. Trap number two, the exclusivity clause. Now, let's discuss a clause that has silently destroyed many earning opportunities, the exclusivity clause. Suppose you sign a contract with a coffee brand. You receive 1 lakh rupees for the collaboration. Sounds great. Then you discover that the contract prohibits you from promoting any competing beverage brand for the next 12 months. Suddenly, you have lost multiple opportunity from other companies. Many creators focus only on the payment amount and ignore the value of future opportunities they are giving up. Exclusivity clause is something that's not bad, but it should be reasonable. A 1 month exclusivity may be something that's acceptable. A 2 year restriction covering an entire industry could severely hit your earning potential. So always calculate the opportunity cost before agreeing. The morality clause. Now, this is perhaps the most controversial clause in modern influencer contracts. The morality clause. So this clause, it allows brands to terminate agreements if it conducts, if it damages their reputation. At first glance, that sounds fair, but here's the problem. Many morality clauses, they are extremely broadly drafted. A controversial tweet, an old social media post, a public disagreement, a political opinion, a misunderstanding, which is taken way out of the context, any of these may trigger termination. We have seen celebrities, athletes, and influencers lose sponsorship because brands concluded that public perception created reputational risk. The challenge is that morality clauses do not define what conduct actually violates the agreement. The result? The brand gets a broad discretion while the influencer carries significant uncertainty. The unlimited liability clause. Now, this is one of the most dangerous clauses creators often overlook. Suppose a brand gives you a product claims and marketing material. You post exactly what they ask. Later, regulators come, they determine that those clauses were misleading. Who becomes liable? Sometimes the contract attempts to place, the entire burden on the influencer. This becomes particularly important in India due to the guidelines which are issued by the Advertising Standard Council of India, which requires influencers to make proper disclosures and exercise due diligence regarding the claims they endorse. Many creators assume legal responsibility belongs entirely to the brand. Unfortunately, influencer agreements often shift substantial risk to the creators. Always review indemnity clauses carefully. An indemnity clause can cause, it often determines who pays when the legal problem arises. If the clause heavily favors the brand, you may be accepting risk far beyond your compensation. Payment delays. Let's discuss every creator's nightmare: not getting paid. The 90 days to 180 days payment delay, I'm sure every creator is aware. Many contracts specify deliverables in extraordinary detail: number of reels, stories, posts, edits, revision, engagement requirement. But the payment clause may only consist of two vague lines. That should immediately concern you. Questions that every creator should ask to protect themselves with respect to the payment is: when will the payment be made and will there be any advance? What will happen in case of payment delay? What if the brand refuses approval repeatedly? What if the campaign is cancelled? Without clear answers, creators often find themselves chasing payments for months. The next trap: free revision abuse. This is an increasing problem that I've seen with a lot of creator friends go through. A brand asks for one reel, you submit it, they request a change, you revise it, they may ask for more changes and more changes and more changes, and it's never ending. Before long, you've effectively created multiple versions of the same content while you have received payment only for one. Professional contracts should clearly limit the revision rounds. Otherwise, creator may find themselves trapped in endless editing cycles. Remember, your time has value, your creativity has value, your expertise has value, and your contract should reflect that. The next trap: your termination clause. Many influencers focus on how a contract begins, but few examine how it ends. Yet, it's the termination clause which often determines who truly controls the relationship. Some agreements, they also allow the brands to terminate immediately without compensation, often require creators to refund payments already received. Some even permit termination based on subjective dissatisfaction. Always ask these few questions. What happens if a campaign is cancelled? What happens if a brand changes strategy? What happens if a product launch is delayed? A fair agreement should allocate risk responsibly between both the parties. Let's talk about the recent industry development. Now, in the last few years, the creator economy has matured a lot. Regulators worldwide are increasingly scrutinizing the influencer market. So in India, we have the Advertising Standard Council of India, which has strengthened the disclosure requirements for influencers and digital creators. Creators must disclose whether it's a paid partnership, content which is sponsored, and material connections with a brand. Consumers today demand transparency, regulators demand accountability, and brands demand protection. Unfortunately, creators often become the weakest negotiating party despite being the face of the contract. That's why understanding contracts is no longer optional, it's essential. So, here are a few practical tips for creators before you sign your next influencer agreement. Never rush. Read every single clause. Always review your intellectual property rights. Either you can go through the clause yourself or you can connect with any lawyer friends. Review exclusivity obligations, termination rights, payment timelines, liability provisions, and dispute resolution clauses. And most importantly, if the deal is substantial, please consult a lawyer. The cost of a legal review is often far less compared to the cost of fixing a bad contract later. The influencer industry offers incredible opportunities. Creators are building businesses, launching brands, earning incomes that were unimaginable decade ago. But success should never come at the cost of legal ignorance. A contract is not merely paperwork. It's a roadmap determining who owns your contract, who controls your brand, who bears the legal risk, who gets paid. The most successful influencers are not just creative, they are informed, they understand their rights, they negotiate intelligently, and they never sign agreements that they do not understand. So, next time a brand sends you a contract and says it's just a standard agreement, remember this: there is nothing called as just a standard agreement. Every clause matters, every word matters, and sometimes the most expensive mistake an influencer can make is not just a bad post, it's a bad signature. If you found this video valuable, comment below what's the biggest red flag you have seen in an influencer contract. Don't forget to like, share, and subscribe for more insights on media law, entertainment law, intellectual property rights, and creator economy. Thank you.